mamu ina akwaba e de bank assertive niti for yanda ne ni konkohwe NDC akachi na nim say some month ago and the sitting president Excellency John Dramani Mahama onya a petition be on the removal of the Chief Justice Mahama Gertrude Øver Saki tukunu niti for all setting up the committee some share ma nim sim no ana palam pliampa ana mo hwe no mu yi Mahama Gertrude Øver Saki tukunu efi akonya kese no so na nim say case no na the call Supreme Court and I'm watching a ßrèak abasa. I'm so the case in the biggest court in West Africa, the ECOWAS Court. And I'm also watching a ßrèak abasa. Therefore, ECOWAS Court so starting change. We create that change. Ada kuma Excellency John Dramani Mahama and the Attorney General Dominic Akutinga Ayeni. Just because of instance, for Ekoso about the Chief Justice Akachinity. For instance, we never could see combining Sensama Ekoso about the ECOWAS Court.
Remove the lid on the details of the reasons why she was removed. And she wants these incidents to be looked at by Ghanaians and fairly and squarely so that an average Ghanaian can determine whether these are the reasons why you can remove a Chief Justice. That really is one of the legs, appears to me to be one of the legs of this legal action, because in the legal action, she has the opportunity for the first time to detail out the conclusions of the committee and the government against her. And she summarizes it in three beautiful ways. And one of the reasons, three reasons for which she was removed, one of them is that she had an expenditure overdrive. The other one was that she had transferred an individual. And the other one was that she had participated in the nomination of new Supreme Court judges in the manner that the petitioner felt was improper, extra legal. Now, on the first one about expenditure, she makes the point in the legal action that this is an expensive, this is a public institution. Expenditures are audited by the Auditor General every year. When the Auditor General audits expenditures of these institutions and there are red flags or there are any adversary findings, such adversary findings are made public, including being made to that entity. So this is a judicial service. She traveled with a family member, and then she was given some money, which is standard, determined by a committee how much is being given. She was given that money. She didn't spend that money. She brought the rest back. The petitioner says that she traveled with a relative instead of traveling with a bodyguard. That's really what the petition is saying, that instead of security, because her policy says that she must travel with security, and instead of that, she swapped it with something like that. Now, yes, there are people who process the travel. Different kinds of people. And the Auditor General, in terms of the impress that was expended, the Auditor General had an occasion to look at it and ask questions, and the questions were answered. And when the Auditor General asked questions and they are answered and he's not satisfied, there are ways of dealing with the ßrèak, etc., etc. So to the extent that the Auditor General, who is the final authority on these matters, had looked at it and had deemed it sufficiently wholesome, she's alleging to the court that the committee ought not to have even been able to look at it without bringing the Auditor General to the committee for a determination of the matter. And in terms of the trial, the Auditor General was not invited to look at this matter. This is the matter.
She could have subpoenaed the Auditor General to come.
Well, that's where ECOWAS comes in with the processes that obtain there. When you subpoena somebody, I don't know whether we're able to mention it. There's a very important somebody from the Office of the President was twice subpoenaed to the committee, and both occasions the chairman of the committee will not allow her to speak. She was subpoenaed by Tokonu's legal team. She says she's a senior staffer at the Office of the President, and so there were some matters that she said that it is within their domain. The Office of the President will know. She was subpoenaed twice, and he will not be allowed to speak. So what this writ is trying to do is to show Ghanaians that here you have a Chief Justice. The Chief Justice has expended expenditure of public money. The system allows the Auditor General to look at it. The Auditor General has looked at it and they didn't find anything wrong with it. A committee then is petitioned and they take up a matter that the Auditor General has looked at and they didn't find anything wrong with it, and they do not even invite the Auditor General to the processes. That's why they were calling for a public viewing of the matter. If the public had viewed the trial like we do election petitions on television, we wouldn't be sitting here talking about somebody was subpoenaed and I can't mention his name. So that's one.
The second one, nature is purely a constitutional.
Fair enough. I don't want to go to the in-camera nature. There are creatives. The Judge Wood is the reason why we see court on television. The Supreme Court actually ruled against it.
No law expressly bars. But
fair enough. But the Supreme Court, in the same election petition, ruled against the application for live coverage. The Supreme Court ruled against it, and it was Judge Wood who, by a fiat, exercising her administrative authority as Chief Justice, allowed the thing.
But this constitutional. This constitutional. This constitutional.
Constitutional provision.
And you see, Paul, there were people or there are other people who.
Fair enough. I don't want to be distracted with the in-camera. So the Auditor General's one is 1. 2. The Chief Justice in her administrative capacity runs the judiciary. She's able to transfer and retransfer and readjust and reassign people in the judiciary. She's able to assign all kinds of people from the lowest to the highest. She's able to transfer Court of Appeal judges from Accra to Kumasi and to Koforidua. The Supreme Court sits only in Accra, and therefore you can't transfer Supreme Court judges. But if the Supreme Court were sitting in Kumasi and other places, she would have been able to transfer them. Yes, a petition that comes to the committee says that the Chief Justice has transferred somebody, and that becomes a subject matter at the committee, that she has exercised her administrative authority. Now, under the 1992 Constitution...
Who is this somebody?
Somebody was working in the office.
Yes.
I'll come to that. Why this issue of transfer even came up. Under the 1992 Constitution, the authorities like the President's Chief Justice and all of those people, discretionary powers.
Yes.
And there are so many discretionary powers in the Constitution. So in Article 296 of the Constitution, discretionary authority granted under the Constitution is regulated. Yes. And Article 296 says that discretionary cannot be exercised capriciously, whimsically, and all of that. Fair enough. So when the Chief Justice power of transfer will be considered as a discretionary authority. Now, the provisions of Article 296 in terms of how discretion is applied to make a determination on whether it has been whimsical, it's a judicial decision. To make a determination that a discretion has been exercised contrary to the provisions of 296, it's not a quasi-judicial decision, it is a judicial finding that ought to achieve that. Forget about that. This particular transfer, even if you can assume that it's whimsical and therefore you can say that, oh, CJ saw the guy and said that, I don't like your face and transferred her, and then you can make a case out of it. This particular transfer is very unique. It was occasioned by the trial of Jachi Kwesen. Now, during the trial of Jachi Kwesen, it was found by the judge and the registrar of the court that it's a whole section of the transfer, the data, the record, the whole section of the text, the report of the court had been deleted. And so immediately red flags were raised and meetings were called. The National Signals Bureau were asked to look at the computer system at the court and make a determination as to who could have been responsible for this. The National Signals Bureau made a finding and had names in the finding. This transfer was occasioned by the findings of the National Signals Bureau. How then can anyone say that such a transfer should be captured within discretionary authority and therefore within the provisions of Article 296, and it must be a quasi-judicial committee that makes a legal finding on the violations of Article 296? How can you say that? So this one other thing she's bringing for the public to look at and determine that this is why your Chief Justice has been sacked, because he occasioned the transfer because somebody was said to have deleted court document of the Jachi Kwesen trial, and when she said this person is therefore transferred, they said that they are coming to a committee to come and look at it, and then they will sack her. The other thing she did was this allegation. This is the last one. The allegation has 3 things. The last one is allegations that she had participated with President Akufo-Addo,
suggested names
somehow
of
or
persons.
rather to suggest names of people to go to the.
So that was contrary to the law.
Contrary to, yes. The Ghana Bar Association,
ought to have known
the Ghana Bar
that was in the route.
The Ghana Bar Association testified before the committee and indicated how it happened and gave it a clean bill of health. The Ghana Bar Association testified because the allegation includes the bar. In the allegations that went before the committee, that's the reason. The allegations includes the bar. Now, the law says the Judicial Committee or Judicial Council